Everybody, welcome to lecture number 8, I guess. I wanted to sort of finish up with filing of a provisional patent application and talk a little bit about non-provisional applications. I want to kind of focus on some of the practicalities so that you can model what you do after some of the examples I set up for you and sort of have in mind the practical advantages of non-provisionals and provisionals and what we call the two-step approach. We've talked about, though, how simple it is to file a provisional patent application. There are no forms available. Very sort of simple flight application. We've talked about this. You have to have a description of the device, some figures that give the patent examiner some idea of what in heaven's name you're talking about, and the transmittal letter and cover sheet that identifies the inventors and gives the title of the invention, the background of the invention, a brief summary. These are the things that need to be included in a specification section. We've already gone over all this stuff. We've talked about claims. You know, as you know, claims are not necessary for provisional, but I think you all now know enough about writing claims and the English language that you can come up with your own claims to be included in your provisional application. I mean, after all, it's your invention. You know what it's intended to do. And it just makes things easier for the patent examiner and more simplified for you later on if and when you decide to go the whole non-provisional route. So here's some examples of some figures that come from a provisional patent application that was filed by Professor Alex Slocum, a prolific inventor, as you all know. This is one of his inventions, one of his patents. This was a successful non-provisional patent application for the aptly named spiky ball foot massager. This is just one of the examples of how you describe in a provisional patent application what it is that you're attempting to get a provisional patent on. And, you know, the old saying is, a picture is worth 1,000 words. I mean, any patent examiner can look at this and eliminate any doubt as to what it is that the applicant is attempting to patent. Just another example. It shows how it's used. So in the first example, it shows the two spiky balls, the cord that connects the two in one diameter. This is an example of how the device is used. Again, a picture, you know, is as good as 1,000 words, at least for a patent examiner. Here's a cutaway of the device so that the patent examiner can fully understand exactly what it is that is the subject of the invention application. And here's the actual abstract that Alex wrote for the invention. Again, I think it helps to look at examples because you'll have something in mind, I'm sure, that you can use this as a model for. But again, simple sort of English language stuff. The name of the inventors, the date of the invention. This is 231 is a blank space on the electronically populated computer form. Title is abstract, and we talked about an abstract last time, but here's Alex's abstract: an adjustable foot massaging roller device for massaging various surfaces of the feet for the general health and comfort of the user, as well as to provide relief for specific conditions such as plantar fasciitis. The device consists of two resilient spherical elements with surface features, where the spherical elements are joined by a flexible cord that holds them within one diameter apart. The flexible cord allows the spheres to roll about non-collinear axes to maintain nearer true rolling contact to reduce rubbing and abrasion of the foot. The spacing between the spherical elements in some embodiments can be adjustable, and the cord can be elastic. There it is in plain English, what it is that these diagrams describe. And you'll need to use plain English to describe your particular invention in the abstract section of your provisional patent application. What's the difference between an abstract and claims? I mean, look at Alex's description here. The difference between abstracts and claims is an abstract is what the invention is, and a claim is what the invention does. But I think you can pretty well deduce several claims from this abstract section. Okay, can anybody write a claim for this particular device? Give me a claim for Alex's device. You've got the abstract right in front of you. So think of a claim.
People will reduce stress and and provide better posture as the food gets tend to adjust better the shoe while.
Yeah, that's pretty good. I mean, remember how you start a claim. What I claim is, right? It's really simple. I mean, English language. What do you got?
Well, I was just going to ask, claims are the only part that matter legally, right?
It depends on how you mean. If you don't have an abstract section, your application is going to be rejected. But with respect to the enforcement of a patent, yeah, the claims define it. Remember, we talked about the outline of the house. You look at a house, you say, I own from the roof to the basement and all the four walls. Well, the claims section concerning a patent is exactly like describing a house. I own everything within these claims. So how about one claim being, I claim that this device will alleviate plantar fasciitis, right? I mean, it's like right in the abstract. Can anybody think of another claim?
For instance, with that kind of claim, do you have to prove it that you that certainly is doing that thing?
Yeah, that's kind of a bold claim for Alex to be making, quite frankly. I think it gives a hint as to how this device was actually invented by him. Alex is a endurance athlete. And you know what endurance athletes often suffer from? Plantar fasciitis. And I think the old saying, necessity is the mother of invention. I mean, necessity really is the mother of invention. Remember my bicycle seat? In this particular case, Alex suffered from plantar fasciitis and was looking for a way to alleviate it. One of the recognized therapies for plantar fasciitis is deep tissue massage. I don't know has anybody ever had plantar fasciitis? Oh, good grief. I mean, you end up walking like on the edges of your feet. It hurts so much, and it usually comes from running, long distances and not treating the inflammatory process. So one of the recognized therapies for it is this deep tissue massage. I went one time because I had plantar fasciitis to Boston Children's Hospital orthopedic department. They have a wonderful orthopedic department. Lyle McKaylee, the orthopedist for the Boston Ballet, works there. Great surgeon. And I got in, they put me in a room with like this, 250-pound sort of like stereotype of like a Swedish, masochist. And she grabbed my feet and started like massaging them with her knuckles. And it was the most painful thing I've ever gone through in my whole life, but it resolved the plantar fasciitis. It's a little masochistic to go through it, but this is Alex's sort of version of that. You can sort of affect your own massage by standing on the ball and rolling it over your feet. I think that in order to back that claim up, you'd have to submit, along with your application, some literature, some scientific literature showing the therapeutic benefits of that type of massage for plantar fasciitis. At least I would. Otherwise, it's you could change plantar fasciitis to various maladies of the foot, right? Another claim is it could just, it just makes you feel good. Can anybody think of another claim for this device? I'll let you think about it. We talked about the cover sheet and all the things that you need to have on it. Alex's cover sheet is right here. Here's another provisional patent application, again by the prolific inventor, Professor Slocum. And these are something called run fins. At least I think he's improved the nomenclature. Spiky ball foot rubbers, not as catchy as run fins. By the way, what does TM stand for? I heard it. I almost heard it. Somebody whispered it. Trademark, exactly. We talked about trademark. Now, does Alex have to put the TM up there in order for it to be a trademark? No, of course not. In the olden days, remember the paintings from the Mona Lisa and all the others? You had to put the mark on them. But with the adoption of the new statute in the United States, all of that sort of having to, remember the Coca-Cola bottle with the trademark or the R? That's not necessary. All you have to do is register it with the United States Patent and Trademark Office. But some people like to put TM up there, like they like to put patent pending or patented, just as a way of letting everybody know that the device is protected. But and in this case, the name. So here's the description of the run fins that Alex did. Here are the prototypes of what he calls the aqua runners. In one case, he calls them run fins. In another case, he calls them aqua runners. I guess run fins is the trade name for this device, which he calls aqua runners. It helps to have access to computational fluid dynamics. If you happen to be a professor at MIT, I guess that kind of helps your provisional patent applications. But I'm sure the patent examiner was very impressed with the computational fluid dynamics. Here are the prototypes, and I'll bring them into you, but I think he took his dog's bowl and bolted them to a pair of fins that he cut the business end off of. And those are your prototypes. The ultimate design, though, which actually, by the way, developed over a period of time, is this. So here's your provisional patent application right here. All right, so his filing date is set in time, set in stone. He has 1 year from this date within which to file a non-provisional patent application. During that time, he can develop his invention, put more money into it, find investors, do all the kinds of things that inventors do in order to perfect their device, come up with claims, come up with a better description, come up with drawings, and ultimately, there's his final drawings that accompanied his non-provisional application. Kind of a far cry from these, but as you can see, oftentimes that's all you need in order for a provisional patent application to be issued. All right, so what happens after a provisional patent expires? How long is the provisional patent good for? 1 year, exactly, 12 months. And the 12-month period can't be extended under any circumstances. That's important to know. So 366 days, you're out of luck. And what happens on the 366th day to your invention? Public domain. Everybody gets to use it. Nobody gets to own it. An applicant who files a provisional patent application must file within the 12-month non-provisional application, a non-provisional application for the patent. No exceptions, okay? If you don't file within the 12 months, you lose all of your rights. A corresponding non-provisional application can be filed at any time within that 12-month period of time. So you can have it ready to go in a month, 6 months, or on the 365th day, but you have to file your non-provisional within that 1 year period of time, that special grace period that is available under the AIA. And once the provisional application is filed, an alternative to filing a corresponding non-provisional application is to convert the provisional application into a non-provisional application by filing what they call a petition, a grantable petition within the USPTO, with the USPTO. But there are disadvantages to that. It's very rare that people convert a non-provisional to a provisional. And the reason for it is because with when you convert a non-provisional to a provisional, the date of the provisional patent goes back to the original filing of the non-provisional. So you basically lose a year. And the idea is to protect the invention as long as possible, so you don't want to lose that year. The best thing to do is within the 12-month period of time, hopefully on the 365th day, file that non-provisional application, have it ready to go. And all you have to do is reference the prior non-provisional application. And your filing date then begins on the date of the non-provisional. You don't lose that that year. This is basically just what I said. Because the term of a patent issuing from a non-provisional application resulting from the conversion of a provisional will be measured from the original filing date of the provisional application. Because of that, it's basically a disadvantage. You lose that year. So by filing a provisional application first and then filing a corresponding non-provisional application that references the provisional application within the 12-month period, a patent term endpoint may be extended by as much as 12 months. So it's basically a way of getting a 21-year protection for your invention. And there are other advantages to filing a provisional application. Remember, under the AIA, the America Invents Act, which was passed in when? 2011, became effective March 16th, 2013. Remember the one that made us all a first-to-file country? So under the AIA, a provisional patent application can be filed up to 1 year following the date of the first sale, public use, publication, or other disclosure of the invention. So remember, that's that grace period that we were talking about. But remember, however, that these pre-filing disclosures, although protected in the United States, may preclude patenting in another country. What kind of country? An absolute novelty country. Remember, absolute novelty countries don't give you that grace period. So again, another reason for filing a non-provisional. If you file that non-provisional and the country that you intend to get patent protection in is a signatory to the Paris Convention. Remember we talked about the Paris Convention, 1883, right? Okay. If the country is a signatory to the Paris Convention, the date on which you file your provisional patent application is the magic date. You're protected from that moment on. Okay. And if you look at a map of the world, I think that almost every single country is a member of or signatory of the Paris Convention of 1883. You know, it sounds like a moldy old document, but it's an 1883 convention that still works. And all the major markets in the world, all of Europe, all of Asia, I think with the exception of maybe Singapore and Saudi Arabia, you know, I haven't looked at it recently, but there's only a handful of countries in the world that aren't signatories to the Paris Convention. And that's a good thing, because if you want patent protection in other countries, you have a whole year from the date on which you file your provisional patent application within which to file a patent application in another country. And it must be respected under the Paris Convention. So if your application for a provisional patent is approved in the United States, it must be recognized by any member nation that's a signatory to the Paris Accord, the Paris Convention. So that's why so you have this grace period in the United States within which to file a patent application. So you have like a year from the date that you disclose. That doesn't help you in other countries, but you do kind of get a grace period from other countries under the Paris Convention from the date that you file your provisional. So what advice do I give everybody that comes into my office and asks me the question, should I file a provisional or should I wait and publish? File it, file it, file it, file it, file it, file it. Exactly. That advice will cost you $5,000 in any law firm in Boston. So look at this. You've already saved $5,000 by sitting through these lectures. That advice alone is, yes?
Have you ever given the advice not to?
Nope.
Okay.
Nope.
No situation in which you should.
The only situation I can imagine was somebody comes in with some device that just doesn't do what it says or isn't worth patenting. Or a few times I've tried to talk people out of spending the money on contraptions. But you know, man, who's to interfere with? You know, I was the guy that said I wouldn't grant a patent to the fluorescent ceiling fan. You know, what do I know? So no, I give that advice to everybody. It's prophylactic advice. You know, you cannot go wrong following that advice, and it takes so little work. You know, really, I showed you Alex's provisional patent applications. Good grief! I mean, it can't get any simpler than that. I think you can do a better one in about 2 hours on your computer. So it's really a no-brainer. And if you learn anything by sitting here for these lectures, if you learn nothing else, you learn that, you've really saved yourself a lot of aggravation. All right, advantages. I wanted to go over the advantages of a provisional patent. Provisional patent, of course, we've talked about, has the simplified filing with lower initial cost, with a 1 full year to assess the invention. And that's important. Think of Alex's spiky balls, or think of the run fins. The original prototype being an upside-down doggy dish and a pair of swim fins that have been cut off and bolted together. Literally, I'll bring them in next week. I'll show you them there. But it takes time to develop, a prototype. You've got to, in the case of a real prototype, not only do you have to have drawings, but you've got to go to somebody that makes these things, and you've got to talk them into building a prototype for you, unless you have the ability, unless you have an injection molding system at home or some other device some other manufacturing ability. You've got to go find somebody who can make one of these things for you. One of the people you might go to is Professor Slocum. You say, I don't know if you've ever been to his Rube Goldberg, sort of basement or garage, but he can build he can build anything. So you might go to someone like Professor Slocum and say, hey, I'd like you to build this prototype for me. That takes time. So from the date that you file your provisional patent application, you're going to develop this thing. You're going to develop drawings. You're going to develop claims. You're going to develop, prototypes. You're going to refine your invention. You're going to perfect it. You're going to maybe have access to computational fluid dynamics that get you to tweak the design. You have a whole year to do that. So one of the advantages of and during that time, you're protected. You don't have to worry about disclosures. You don't have to worry about anybody stealing it from you. So that's really important, and it's important especially if this turns out to be commercially exploitable. Selling 1 million run fins would be kind of a good thing to do. So you want it protected, and that provisional patent application gives you the opportunity to do that while you perfect it. Provisional patent establishes an official U.S. patent application filing date. That's oftentimes important. Seems silly. But it's oftentimes important because when there are patent contests, who files first? We had a question last week. What if they file on the same day? Well, it really, the date stamp on the application is what determines it. Oftentimes you have contests. People will file applications to cancel your patent, even if they don't have really, really good grounds. You'll find a lot of frivolous applications to cancel patents out there. So having a firm date is really important, and the provisional gives you that. You can write patent pending on the thing if you like, once you've filed your provisional patent application. And as I said, the provisional patent application begins the clock ticking on the Paris Convention. So, and of course, you can immediately exploit this commercially because you don't have to worry about disclosing. So you go to the bank and you say, I have this great idea, I'd like you to loan me $20,000. Or you go to your mom and dad and say, I have this really great idea, I'd like you to loan me 20, or your rich uncle or aunt. You know, this is how inventors get started. I told you I was sitting in my doctor's office thumbing through the book, and it had a picture of garages and basements on one page. And it had listed on each garage where Apple started, where Facebook started, where every gigantic company that you can think of today all started in garages, all started with people going to their family and borrowing what money they could. This is really how it happens. And so that provisional patent application gives you time to file, protect, and then go out and get the money from your rich uncles and aunts. Yes, sir.
So it says that you can put patent pending on your product when you're within like the 1 year provisional patent
Yes.
period. Once you've actually like filed the non-provisional patents,
Yes.
are you still allowed to say patent pending until it's
Yeah, until it's approved, and I'll go over the time frame. Somebody did ask in the class earlier about 2 weeks ago, about whether these are published. And I may have misspoken. Provisional patent applications are not published by the USPTO. So you can't go on their website and look up pending provisional patent applications. You can see those that have been granted, but you can't see those that are pending because they're just provisionals. And one of the things that the patent law provides is that when you file that provisional, it remains secret as far as the public is concerned until it is approved. And the time period for approving them is usually more than a year, so I'll go into that. So the one good thing about provisional patent applications is it kind of gives you that secret date that no one's going to know about. And so if there is a contest later on, you just waive well, what you get is an electronic advice from the USPTO saying your application has been received, and it'll give the date and the time on it. That's literally how it's done. More advantages of a provisional. Provisional is not published, as I said, by the USPTO, and so it preserves the application in confidence without publication in accordance with patent law. A provisional patent application permits the applicant to obtain USPTO certified copies. So if you ever need to, for instance, prove it to your bank, or if your uncle, before he loans you the money, wants to see if you've filed for this, these things can be important. If you want to commercially exploit it, if you're shopping this around to like Walmart, or you're shopping it around to Amazon, that certified provisional patent certificate from the USPTO allows you to do that. If you get into discussions with Walmart, they're going to want to see that kind of stuff. You know, if you have a better mousetrap and you're thinking about selling millions of these things, you know, does anybody watch what's that show where they have the entrepreneurs? Yeah, right, exactly. All right, Shark Tank. I mean, that's really how it happens. I mean, you know, not really. I mean, it's not Shark Tank, but you know, that's, you know, you go to let's say you're in the field of, let's make it more realistic. You're sitting here at MIT and you're working on a medical device, maybe a shoulder replacement, something that doesn't fail 90% of the times like the ones today. You've come up with an idea. Well, you'll go around to different societies and groups that are involved in that type of engineering, and you will disclose your invention to them in the hopes of getting funding from them, in the hopes of getting support for further development. Well, as long as you file your provisional patent application, you're protected during that period of time. And you're free to develop the funding that will hopefully enable you to commercially exploit it. I mean, I talk about mousetraps all the time, but that's an example of someone that we had in a class last year who was working in the biomechanical lab here and had come up with a device that they wanted to market to every orthopedic surgeon in the country. And they did. And I don't know what happened, but I'm sure they're very long on their way to being very wealthy now, because they really came up with a better way of doing something in orthopedic surgery. an intermediary device that I think everybody is going to use. Yes, did you have a hand up? Just holding your head up? Okay. The provisional patent application allows you to submit additional names. So, okay, you go to a society, you have this great idea for an intermediary device. Everyone is going to be putting this titanium device into spinal columns. But you have somebody that has some better ideas in terms of materials or in terms of design. You bring them in on it. Make them your partner.
Check out these results.
Who said check out these results? In any case, you have that additional time within which to add inventors, and so development of a device doesn't just mean you sitting in your garage or at your drafting table coming up with tweaks in the design. You may meet other people that have other ideas that contribute significantly to the development of the device and make it more commercially exploitable. A lot happens in that 1 year period of time when you file your provisional. If you're an inventor, a lot happens in that period of time, and meanwhile you're protected. You can do all those things without worrying about losing your spot. Another possible advantage of filing the provisional patent application would be that you could find a good product company or manufacturer during that 12-month period of time. All right, I've talked about Amazon, I've talked about Walmart, but speaking of the intermediary device, there are a lot of manufacturers in actually the Kendall Square area that deal with this type of biotechnology, and you literally go there with your little suitcase with your device inside of it. You sit them down, you sign them up to an NDA, and you show them. And oftentimes they take that to their board of directors and you get funded. That's literally how these things happen. All right, other possible advantages of a provisional patent application is when a non-provisional application is filed, the USPTO then places the application in the queue to be examined. So I wanted to give you an example of the time period that it takes to get these things done. So the average wait time for an examiner to look at a patent application is about 24 months. Which is actually probably a little bit longer these days. And that's before the patent examiner will begin the examination process. And we talked about the examination process. It's a dialogue. It's a back and forth with the patent examiner. So one of the advantages of filing a provisional patent application is when the non-provisional application is filed, your place in the queue is saved. You have that filing date that preserves your rights, no matter how long it takes the USPTO to get to your application. Simpler applications get looked at more quickly or sooner. More complex applications sometimes take 3, 4, even 5 years in terms of the process of getting through the non-provisional application process. So after examining the patent application, the examiner will negotiate with you, talk about tweaks in the design, talk about prior art, talk about advances and how it is distinguished from prior art, talk about limiting your claims. You might say that it can do anything, and they're going to want to get you to limit the claims, all right? And that's a negotiation, because you don't want to give up, claims that you think you can prove, and the patent examiner wants to limit you to what you can prove. So there's a negotiation that goes on between the two of you. And then the examiner and the inventor's attorney can come to an agreement on the scope of the claims, and then the average wait time from the date of filing to the issuance of a patent is 3 years. Again, sometimes that can be as long as 5 years. So therefore, in the average case, if everything goes well and it's a simple invention, the patent will be issued about 3 years after the date of filing the non-provisional application. Another advantage to the two-step approach, that is filing a non-provisional and then a provisional. Yes, sir?
So in that case, how can people trust you if you tell them that you have patented it?
Well, you can't tell them it's patented until it's patented. You can tell it's patent pending.
How can they trust that it's patent pending and not go and try to patent it?
Well, because you get that certificate from the United States Patent and Trademark Office that says that a provisional patent has been applied for. And you actually carry that certificate with you when you meet with the board of directors of the of the biomechanical engineering lab that you're doing business with, or with Walmart or Amazon or whoever it is that you happen to be doing
So
business
you have
with.
an official
Yeah, but-
receipt. You just don't put patent pending yourself.
Well,
on PowerPoint.
you can, but you asked what do you do if someone asks you to prove that? And what you do is you show them your certificate from the USPTO. Yeah. Yes.
So anything that applies for a provisional patent is automatically patent pending, so you could put patent pending on anything.
Sure, you can. You can. Now, after 1 year, if you haven't filed a non-provisional, then it would be false and misleading for you to say something was patent pending, because what happens after 1 year if you haven't filed a non-provisional? It goes into the sink, into the public domain. You've lost your right to pursue it. So anyhow, yeah. So the example I was giving, this slide actually comes from the person that was designing the intermediary device last year. Oftentimes, boards of directors, when they decide to fund something, will give the inventor a deadline that you have to comply with. So where you have a developmental deadline, because the board of directors wants to take that to a customer, okay, or present it at a trade show or otherwise make it available to the public, having that protection is essential. So if you have a deadline to make an offer or for a sale or for a public showing, but that you believe you're going to need to further develop the invention, add features to it, as is in the case of this intermediary device that I had in mind, the provisional patent application with that 1 year to develop it is like a godsend. It really is, and it's so much better than being in an absolute novelty country, because you really have this whole year to develop the thing. You can see why inventors petition the Congress to give them that 1 year period of time. You don't have that period of time in absolute novelty countries. A fun example, or you may not think it's fun, I thought it was fun, but I wanted to illustrate for you what it costs, and in other words, and also give you a concrete example of what you can expect to do. So let's consider the following example. Somebody comes up with a better mousetrap, and the cost of preparing a non-provisional application is $5,000 in attorney's fees, and that would be for a very simple application. So the filing fee for non-provisional is for a small entity, like a you and me mom and pop entity, is $530. Therefore, the total cost of filing the application in a one-step non-provisional method is $5,530. Sorry for the math mistake. I don't know what I was thinking. So a one-step non-provisional application for a very simple device, $5,530. $5,000 for the attorney's fees and $530 for the application. Okay? So that's what you do if you go straight to a non-provisional. But if you take the two-step approach and start with a non-provisional application, with a provisional application, you save, the first thing you do is you save $2,500 in attorney's fees, because you're not asking the attorney to come up with any claims section. All you're asking them to write is specifications and an abstract and a title page. So you save $2,500 to start with, because you don't have to write up any claims. And if you include any claims, you've probably already thought of one clever or two clever claims that you can include there without asking the attorney to write it themselves. So the filing fee for a provisional application is, for a mom and pop entity, is about a fifth of what it costs for a non-provisional, $125. So therefore, the total cost to do a provisional application is $2,500 for the attorney to write everything but the claims, and another $125 for the filing fee. So it's $2,625 versus $5,500 and $5,530. So you save money going the non-provisional route, at least initially. So the upfront cost is about half. So a non-provisional application claiming the benefit of the provisional application as we said, has to be filed within 1 year. So assuming there are no changes in your mousetrap, that it's exactly the same as what you conceived of when you filed your provisional application. So when you file your non-provisional, you have to add, if you haven't figured it out for yourself, another $2,500 in legal fees and the higher application fee. So it brings the total cost of filing the patent to $3,030. And it's what is it, $125 more than going the one-step route, but you've pushed those expenses out. And hopefully you've either come up with the money or you've got somebody to invest in your invention for you. Now, when these costs are $20,000, $30,000, $40,000, because sometimes that's what it costs in legal fees, it makes a lot of sense to push those additional expenses out as far as you can. Oftentimes you come up with an invention, you don't have any money, and oftentimes you have money, you don't have any invention. So it's better to file the provisional application and push those costs out later on if you can. The difference, even though it's a little bit more expensive to do the two-step approach, you buy time and you protect your device in the meantime. That's one of the financial advantages of the two-step approach. And this is the math. So it costs $125 more to do the the two-step approach as opposed to the one-step approach, which is really sort of negligible, and you have all that time to develop the money. In a way, you get to use somebody else's money, or at least use your own money, for a year before you have to actually put it up. So the two-step approach is financially probably a better route to go unless you're really well-to-do or have family that really wants to invest in your invention. Just a few words about applying for a non-provisional patent. So I just want to illustrate the differences between a provisional and a non-provisional because it's important for you to know. Here are the things that you have to have, or here are the features or characteristics of a non-provisional as opposed to a provisional. Higher filing fee, $530 versus $125. And if you go on the USPTO website, depending, if you're a group, if you're a company, if you're a partnership, the filing fees are higher. But let's just say, simple invention working out of her basement, it's a $530 fee versus a $125 fee. Of course, more complex and sophisticated drafting, upside down doggy bowls bolted to a swim fin versus sort of sophisticated engineering drawings. A specific application format is required, claims are required, and this is where the rubber meets the road in terms of your attorney's fees. Of course, if you're building a mousetrap or spiky balls or swim fins, maybe the claims aren't that sophisticated, you can do them yourself. But if you're talking about gene editing or an intermedullary device or some process or method for coming up with, how about a new way of exfoliating, graphene, the claims section in that is complex, and you're going to want to have spent money on someone that knows how to draft those claim sections. A declaration is required, which is very simple. It really basically says who you are and how your invention came about. The information disclosure, there's an information disclosure statement, again, basically how the application came about and who you are. You have to certify that there are no government funds used in it. You have to certify that you're the owner of the invention, that you didn't develop it at MIT and are subject to some sort of agreement with MIT where they get to share in your intellectual property. Then, of course, it has to be examined by the USPTO, which takes at least 3 years. And if not precluded by prior art, and if adequately explaining the invention, it will mature into a patent that confers the right to prevent others from making or reproducing what it is or marketing what it is that you've come up with. So the protection you get with a provisional is the same as the protection you get with a non-provisional, It just costs a lot more money and is much more time consuming and complex to get the non-provisional. And that's worth it if your invention is worth developing, and if not, you walk away from it. Yes?
So once you file your your provisional and the 24 months pass and you're ready.
12 months.
12 months pass and you're ready to file, right? Do you have to pay again?
Yes. So, well, unless you convert, and the fee structure is different. The question is, if you decide to convert or mature your provisional into a non-provisional, do you have to pay a fee again? Yes, there's a separate fee for filing a non-provisional application. But usually it's tiny compared to the developmental costs. So, the filing fees are really not the bar to a non-provisional. What really is the economic bar to a non-provisional is the developmental costs oftentimes. Computational fluid dynamics, in order to prove that your invention is aerodynamic or aqua efficient, is a lot more than the filing fees. But yeah, the separate filing fee is required. Yeah, Claudia.
I was wondering if what's provisionally patented isn't disclosed, then how will other people know if they're violating provisional patent?
Well, they won't until it's approved. But this is one of the reasons why you go ahead and you file your provisional patent application to protect, because we use these examples. Inventor A and company A comes up with an invention in February, and in March, inventor B comes up with independently the same thing. Who wins oftentimes there are races to the USPTO to determine who wins.
Can you get punished for violating a provisional patent but you didn't know about
No, if you did not know, then the damages for willful infringement are not available. And depending upon what the other side did with respect to disclosure, did they disclose and not file? Did you file before they filed? There may be dual use situation. So the answer is, of course, with every answer, it depends. But if you don't know about it, you're not going to be held liable for it. But of course, you'd have to go in. Hopefully it wouldn't come to court, but your lawyers would send a letter to the other side and say, she was working on this patent. Here's, the information. Here's the disclosure. No harm, no foul. Okay. Question in the back. Somebody had one.
Yeah. How do these fees compare to
To maintenance
maintenance fees?
fees?
Yeah.
What do you mean a maintenance fee?
I've just heard that once you get a patent, there's significant maintenance fees.
There really isn't. I mean, they're less than the original filing application and invention filing, and it depends on the invention and who you are and all that sort of stuff. So if you're a big biotech company, those maintenance fees are actually significant. But if you're, Steve sitting in his garage, tinkering with an upside-down doggy bowl and a pair of cut-off fins, they're negligible. And you can look those fees up on the USPTO website. I don't carry them in my head, but for small inventors, they don't mean anything. For giant engulf and devour corporations that spend billions on their inventions, they can be significant. Okay, that's it, folks. That's what I got for today. Make sure you get breakfast next week, Tuesday and Friday. I have a surprise for you. So you have to come to class to find out what it is.